Hello, my name's Sophie Llewellyn-Smith. This is a speech about the pros and cons of common law systems. Ladies and gentlemen, I wanted to write a speech about the legal system in England. I could say England and Wales, but the system in Scotland is quite different. And the first thing that came to mind when thinking about what to say was simply that the legal system in England is quite different from that of two-thirds of the countries in the world, and certainly most of the countries in the EU. This is because England is a country with a legal system based on common law. What does this mean? It means that we don't have a written constitution, and although we do have laws, which are known as statutes, adopted by the legislative process, in other words, adopted in Parliament, we also have another system that runs in parallel, where it is the judges who make decisions, who deliver rulings, and who develop precedents. A precedent is the idea that a decision that has been made by a judge in a case will then have a binding effect in similar cases in future. The precedents are binding on judges, as I was saying, and the difference between this and a civil law system is that a single decided case is binding. In a civil law system, you would need an accumulation of cases over time to create jurisprudence, whereas in a common law system, you just need one decision in a case, and that can then alter the course of the law. This is a principle known as stare decisis, or stare decisis, I suppose, depending how you want to pronounce the Latin, which is the idea of stability in the decision making, that the decision should be the same as the decision taken previously in a similar case. There are, of course, other differences between common law systems whose origins lie in the English system some time ago, and civil law systems, which originate really in Roman law via the Napoleonic Code. The most obvious difference, perhaps, is the fact that common law systems have an adversarial system where in a court case you would have a prosecution and a defence, whereas civil law systems use an inquisitorial system, and that is where you would have an examining magistrate who would carry out an investigation if there had been a crime, but that investigation covers both sides of the argument of the case, if you like, and then all the evidence would be brought to a judge. But back to common law jurisdictions, in which, by the way, 1/3 of the global population lives, chiefly because of the legacy of the British Empire, which means that Commonwealth countries tend to be common law systems. I wanted to talk a little bit about the pros and cons of a common law system. And you'll find that for virtually every pro, there is a matching con. One advantage then, the first advantage of common law systems, is that statutory law often takes a long time to change and adapt, whereas with a precedent, you can change the law very quickly. You just need one case, one decision, and that can create a precedent straight away. Common law also allows a person to expect some sort of reasonable compensation via the legal system in a new situation, without having to wait for the legislator to identify the need for a new law, to debate it, and to pass it, which could take years. So common law can react to real-life situations as they arise. And common law can also react to something unforeseen by the legislator, because the legislator tends to make broad and generic laws which then have to be interpreted. But of course, it's impossible for a parliament to foresee everything that might happen. For example, the parliament that was passing laws in England 50 years ago couldn't say anything about cybercrime because the internet didn't even exist. Whereas common law could react quickly to new types of crime, for example. So, common law is based on certain principles which are great advantages. For example, consistency. Common law, as I've said, is based on precedent, so it's not based on the personal views or bias of a trial judge, for example. At the same time, common law can be flexible because it is possible to challenge precedents. And common law can be speedy and efficient. Judges and courts can make the law while they're reviewing a single case. So that means they're more able to adapt quickly to changing social mores, for example. Society has changed dramatically in the past few decades, and that has led to shifting patterns in the types of crime that we see. And common law is faster at adapting to that and creating relevant precedents. Now, there are, of course, disadvantages as well. And one of the clear disadvantages of a common law system is that the laws are not all stated clearly and unambiguously, unlike the statutes in a civil law country. And as a result, you need a lawyer to make sense of the law and to argue for a particular interpretation. If you're involved in a case, your lawyer might have to go and search through all sorts of previous cases to try and find a precedent that could apply in your case. And there are important implications to this, that if you commit a crime, it is not an excuse to say that you didn't know it was illegal. People are supposed to know the law. But it's difficult to know the law in a common law country. Of course, you can know the statutes, you can look them up, but you can't look up precedents in the same way. There's a 1,000 years of case law. You can't go and read up on all the cases. So that's one difficulty of a common law system. Another more abstract difficulty is that the precedents are created by judges. In other words, the judges are making the law. But if you're keen on a strict separation of powers in order to avoid abuse of power, then judges should not be legislating. They should be enforcing the law. Other disadvantages of common law systems. The common law can be old. It still contains outmoded concepts. It's not proactive, it's reactive. By this I mean that courts can only adapt common law ex post facto. They can't anticipate. The courts or the judges can't decide that some of the laws are outdated, some of the precedents are outdated, so they ought to be changed. No, a precedent can only be created if a relevant case comes up. You could also argue that common law is easily overridden because it can be overridden by legislation if Parliament decides to legislate. And you could also argue that common law is undemocratic because the Parliament is elected and judges are not. Well, there we have it. That's a brief and very superficial introduction to the advantages and disadvantages of common law systems. From the point of view of my work, probably the biggest thing to say is that when I'm in a meeting of a legal nature, and I sometimes do work in the Civil Law Committee or the Criminal Law Committee in Brussels at the European Commission, it can be very difficult because the member states are arguing from very different legal backgrounds and very different systems. Thank you.